episode. I'm Praveen Gautam, your trusted marketing advisor. I help entrepreneurs and enterprises to build a digital brand and monetize it. And thank you for checking this out from different channels, including Facebook, Instagram, LinkedIn, and obviously in YouTube as a Talking Legal. All right. So recently, we have been received a number of inquiries about wills and estate, specifically in Queensland and a number of the other states, but more on Queensland. And that's why we have a principal lawyer today at our show, Len Watt. G'day, Len. Great to have you today.
G'day, Prabin. It's great to be here, and it's actually good to, I suppose, spread my wings and talk about something other than construction.
Oh, you bet. You
Yeah,
bet.
yeah,
You're always passionate about legal, so providing the business solution for them. So why not, mate?
yeah.
Now, obviously, before we jump, I also noticed your new logo. So, would you mind just tell a little bit about to our viewers who have no idea, obviously, about the new logo or new brand, please?
Sure. So in November last year, we purchased Matthew Love Family Lawyers, which was a long-standing family law practice that's based at Capella Bar in Brisbane. As part of the transition from the Matthew Love brand to that particular part of the business becoming more a part of Becker Watt, we are changing the logo, which is the one that's being introduced tonight as part of this particular feed. And the name of the practice will be changing to Love Family Lawyers. With all due respect to Matthew, who is a respected practitioner, we're just sort of moving on and creating a slightly different, but hopefully respectful brand to grow what Matthew started.
Awesome. Congratulations to you and your team, Len.
Thank you very much.
That's great. All right, so let's go a little bit deeper here.
Yep.
The viewers who are watching this right now, obviously, they have a number of questions, but I picked up one of the questions about family provisions claim made against wills and estate. So they're a little bit confused about, and so Len, if you would help us to understand what is family provision applications or a claim.
Okay, so this is an application that is made pursuant to the Successions Act in Queensland, and it enables an entitled or an eligible person to make an application to the court seeking that an adequate provision be made for their, and taking words from the Act, proper maintenance and support from the deceased person's estate. So it's commonly called the family provision claim. These types of claims arise when a particular member of the family is not considered in the will of a person. So hence, why it's very important to make sure that when wills are being drafted, that all the people who may legitimately have a claim or expect to have some form of provision made within the will are catered for and in some way or form.
Thank you, Len. That's a great that's a very clear statement there. So on that note, then who is the eligible person on for that claim?
So an eligible person is generally a spouse, child,
Right.
or dependent of the deceased person. So a spouse can include a husband or a wife, a de facto partner, a civil partner, and a dependent former husband or wife or civil partner. So if the deceased person has multiple spouses, it can be a number of people. So very important though to remember in relation to a spousal claim, the Act specifically states that the relationship should be in existence 2 years prior to the person passing and end when the person passes. So in the unusual circumstance of a person maintaining more than one relationship, such a claim can get quite complicated, but technically it is possible. A child will include a natural child, a stepchild, or an adopted child, and a dependent means a person who is wholly or substantially maintained or supported by the deceased at the time of his or her passing. So that can generally be a parent, or a child under 18, who may be at the time of the passing dependent upon the deceased to support them.
Right. Thank you, Len. I think that gives a very clear idea. Obviously, what you're saying is pretty much those who are in the applications are on the claims, even though they are deceased. Yeah.
Yeah, that's
All right.
Yeah.
Okay, guys and girls, look, if you're watching this right now, feel free to like, share, and comments. So obviously, feedback is so important, and that's where we are bringing the Q&As in our sessions. We see the great interactions and great reaching out to a number of audience. So yeah, next episodes, obviously, we will try to cover up some of your questions as well. So if there's any specific questions you want to ask Len or his team, yeah, feel free to just jump down and just write down the below comments here. And today we are talking about family provision claims made against wills and stay. All right, let's go deeper here, Lynn, then if that's okay.
Yeah, of course.
How does the court approach this type of the claims?
So there are clearly defined principles upon which the court must act. This is a very old area of the law. So the provision of wills and the passing of property via a will is centuries old, and almost dates back to 1066, when the foundation of our modern law with William the Conqueror. So it's a very, very, very old part of the law, and therefore there are defined principles that the court must act upon. So there's no power to rewrite a will upon principles of fairness or justice, but the court must decide whether the gift to the party making the application, if there is one, is adequate. So then from there, if the court finds that the gift is not adequate, then it has the discretion to make a provision, which is usually a sum of money, for the applicant as it thinks fit. So there are a number of factors the court considers when determining a family provisions applications, which will include the applicant's financial position and needs now and into the future. So if the person has been quite heavily financially dependent upon the deceased, then there is an expectation that will continue upon passing. The ability of the applicant to meet their financial obligations. So any physical, intellectual, or mental disability that the applicant may have. The size of the estate, which is a very important point. Normally, the larger the estate, the more likely a claim of this type will occur. Any contributions that has been made to building up of the deceased estate, or even to maintaining the welfare of the deceased. Sometimes a family member or even a friend may take on the role of carer with an expectation that there would be a gift in the will, and make an application if such a gift is not forthcoming. So the standard of living that the applicant had during the deceased's lifetime, the relationship, and lastly but not least, the wishes of the deceased. That is something that must be considered by the court. However, all this is weighed up, and there is discretion given to the court to actually make a gift or award an amount to the applicant based on these elements.
Interesting. You missed you mentioned about the final, their wishes. It's interesting you say that. Then what are the steps in making a family provision applications?
So
Then
very defined. So the applicant must give. So if a person is going to make an application in relation to a family provision claim, they must do so within 6 months of the person passing. Within 9 months, they must file their application with the court. So from there, the executor agrees to a timetable proposed or negotiates other dates with the applicant. That's 14 days from the service of a draft directions order, which is normally included in the application. Um, Basically, then from there, the parties generally go through a period where they look to try and negotiate a settlement. And it's very common that these things are settled at a mediation. And failing a mediation, a trial date will be set, and the matter will be determined by a judge in accordance with the principles we talked about earlier.
Hmm. So just on that note, the point the viewers who are watching this right now, 6 months before, yeah.
Yes. So and it's quite strict too. There's always an ability within the law to make an application for something out of time.
Yes.
But there has to be particular reasons why, and they have to be, it's not just something that the court will just allow willy-nilly. In particular, in relation to these types of claims, there has to be a significant reason as to why someone is able to give an intention, or even bring, or even bring the application inside the timeframes which are specifically stated in the Act.
You bet. Thank you so much, Len. So viewers watching this right now, what should they do? What is the call of action? Anything they can, you and your team can help them?
Well, now this is the first thing is to I think give the proper importance to the drafting of a will that it deserves. It is a very important document. It's not something that, and I know that there are various kits available, but I do not believe that it can be, in personal opinion, adequately drafted from a free kit. Each individual circumstance has to be considered. For example, thinking about all of the people who may have a claim and making allowance for them within the will. If these types of things are not considered, it can lead to great expense to the estate later on as the parties fight in the courts to determine what the outcome should be. So first of all, see a lawyer to draft a will. That's number one. Either one of our team or your own lawyer. But very first thing is see a lawyer.
Right. So definitely. So okay. Rather than trying to, being technical, trying to reinvent their own wills, and trying to, it is better to find the right trusted advisor, legal advisor.
A will is a very technical document. The creation of testamentary trusts and the ability of those created entities to be able to hold and utilize property, etc., is very important and has to be carefully considered. The provision for younger children under the age of 18 and who's going to have responsibility for property for them, who's going to be the executors of the estate, etc., etc. And the thing that often goes along with this is the enduring power of attorney as well. So making a will, it's also important to look at a power of attorney. So if at some point in our lives we all potentially reach a time when we don't necessarily have capacity to make clear decisions. So having a power of attorney appointed as someone that you know now and trust means that moving forward, that's not a role that's taken over by the public trustee, for example, which sort of then means that the person doesn't get that individual personal touch that they would from a trusted family member.
You bet. Now, those viewers who are watching this right now and they are in Queensland, obviously, if you, if they want to reach to you or to your team, what would be the best contact, Len, please?
Well, generally, I suppose at legal, 1300 at legal is.
Sorry, guys. Just the connection wise, but we just lost the Len. But if you, all the details are just below 1300 at legal, and obviously the best phone number is also email address is info@bakerwatt .com.au. All right. I hope that's been a value to you. So yeah, we talked today in this episode. We talk about family provision claims made against an state and wills. So I hope feel free to give a thumbs up, comments, or like, and and just let us know how this episodes has been, and we will definitely cover up some specific questions or any topic which you are facing right now. I hope it's been value. Call out, take care, and bye for now.